I think over the last year, we have seen a growing movement of people calling out the death penalty for what it is, right? Which is a harmful and oppressive tool that disproportionately affects racial minorities and the working class. At the same time, we have seen an unprecedented pushback from the state surrounding the use of the death penalty, right? And that pushback takes place in different forms, right? One is the tired rehearsal of the deterrent effect of the death penalty, right? Another, the kind of poorly designed public opinion surveys that they like to cite, showing widespread support for the death penalty. And yet another is the kind of propaganda and media blitz that the government and the Minister for Home Affairs is going on. Right. This evening, however, I want to address a kind of slightly different aspect of what upholds and underpins the death penalty in Singapore. Right. That of the criminal legal system and the law as a whole. Right. I think much of the public attention around the death penalty is often drawn to kind of ongoing court proceedings and applications that are put in by the inmates before execution. Right. Beyond reprinting kind of government press releases as if they were actually news. A lot of reporting that you see in mainstream media is about court proceedings itself, right? And that's for a number of reasons, right? First, of course, is the repressive media environment in Singapore. It shuts out alternative narratives and kind of information about the people on death row, their families, and the impact it has on them and their communities. Right. Second, despite the claim towards open justice as a principle that a legal principle that legal systems subscribe to, actually the everyday operation of the death penalty is extremely opaque. We know very little about the conditions of incarceration beyond what families tell us. Right? But I think most crucial is actually the fact that the legal court proceedings and the legal system itself function to cast a view of justifiability around the use of the death penalty. Right? And at the heart of kind of justifying the exercise of state power is the legal process itself, right? It's a system of rules that claim to be neutral and impartial through principles such as due process and fair trial and finality of judicial proceedings, right? These terms and principles often emerge when we read kind of state responses to criticism around the death penalty, and also in the decisions and the judgments by the court when you read them, right? And the effect of these systems of rules and processes is to try and form a kind of coherent internal logic of rules that direct judgments and decisions around people's guilt. Right? But I think it's also a logic that serves a crucial public function. Right? You often hear the aphorism that justice must not only be done, it must also be seen to be done. Right? This aphorism is quoted by lawyers, ministers, judges of the Court of Appeal, right? And it quoted endlessly. Right. I want to suggest that that aphorism actually cuts both ways. Right. While the open performance of justice is framed as a value of the legal process, the content of justice, or what justice actually is in substance, is also produced and created through the public performance of the legal system. And oppressive institutions engage in the bare denial of its own harmfulness when it impoverishes and imprisons people. So returning to the aphorism, justice must not only be done, it must seem to be done. What is this justice that we are actually talking about? What is its content? And who does it belong to? I've been thinking quite a lot about the case when 24 inmates brought an application around the access to justice days before the execution of Abdul Rahim in August. And this was a case about whether court orders and the threat of court orders actually deterred lawyers from representing death row inmates in late-stage proceedings. And such a case, which normally would take months, right, following normal court timelines and procedures, was shortened into a mere span of a week on the grounds that the law, the execution, must take its course. But what gives primacy to the date of execution stated in the notice? What makes it such an immovable priority that any kind of legal proceeding, when its execution schedule must race to its conclusion, seemingly defying every kind of common sense definition of fair trial and due process? I think there are two answers to this question. Right? The first is that fair trial and due process are understood by the legal system in ways that are extremely minimal and diluted. This, of course, is by design, right, to grant maximum leeway for the exercise of state power. And the second, to me, is that the truth of the matter is this. these principles don't actually serve as a counterbalance against the undue exercise of state violence. Rather, being empty of any kind of meaningful substance, they are actually weaponized to justify state power and state violence. I would actually encourage everyone to kind of read section 313 of the Criminal Procedure Code. Right? There's no clearer indication of who actually exercised decisions to kill and what the legal process for that is. Right? Executions are ordered by the President following the advice of the Cabinet. And if you read section 21 of the Constitution, it says the President must follow the advice of the Cabinet. Right? So all this leads us to kind of a wider conundrum, I think. What now if no amount of due process can justify state murder? What now if no degree of finality of legal proceedings should lead us to say, no more and therefore this person must be executed? What reference points for justice do we actually have? Right? If the law cannot be a reference for our values by which we collectively organize our society. Right? And where the law has historically been used, right? Whether it's the death penalty, the ISA, other kind of fake news laws and other kinds of state instruments, when it's historically been used and continually used to sustain the conditions of domination and oppression. Actually, we need to rethink where our notions of justice actually come from and how we arrive at that. Right? And I believe it comes from us, ultimately. Those on death row, their families, the communities affected by all the ills of state oppression and capitalism. And here I want to read out a quote by the legal scholar Maria Mitsuda, who talks about where do we start on the long road to freedom. Right? She says, their anger, their pain, their daily lives, and the histories of their people are relevant to the definition of justice. The personal is the political, we hear from feminists. And everything is political, we hear from communities of color. Not much time is wasted in those communities arguing over definitions of justice. Justice means children with warm bellies, full bellies sleeping in warm beds under clean sheets. Justice means no lynching, no rapes. Justice means access to a livelihood. It means control over one's own body. These kinds of concrete and substantive visions of justice flow naturally from the experience of oppression. When we fight for the abolition of the death penalty, as a linchpin of the carceral and punitive system that there is, what we are looking to undo is actually the hold that legitimized state violence has on us. We seek alternative values and principles on which our society and communities should organize with. We reclaim ideals of justice and fairness and equality for ourselves, to serve our needs and not the state. Abolish the death penalty.